Welcome again. This is still 2023 August paper, and we'll be tackling question 5 of that paper. Describe the following principles. Number 1, utmost good faith with reference to insurance contracts. Utmost good faith is the principle of uberimae fidei. Utmost good faith. Principle of uberimae fidei, and what it simply says is that you must enter into a contract, an insurance contract at that, in good faith. And what this means is that you must not be, hiding some other material facts that can change the decisions of the underwriter. So you are simply supposed to disclose all material facts that are relevant to the contract in question, which in our case is insurance contract. So uberimae fidei, disclose all material facts. Don't go there with an ill intention of benefiting by hiding some critical facts which might actually be necessary in the process of underwriting, basically in the process of considering whether the company should go ahead and enter into this contract or not. Remember, there is asymmetric information. There is information and the company, in most cases, the insurance company doesn't know this information. So unless you disclose to them, they might not have all the information that they require to make an informed decision. That's where the principle of utmost good faith comes in. That disclose all material facts that are key in decision making prior to entry into the contract. Then number 2, Roman 2 of this part A of this question, adverse possession with reference to ownership of land. Adverse possession with reference to ownership of land. This is a legal process where there is the non-owner of a property possibly gains the title to that piece of property, gains the title, that is the ownership. He gains the title. He is a non-owner, but he now gains the title of ownership of the piece of land in question. Normally there are some reasons for that. In most cases, is after a continuous usage of that particular piece of land, a long period of time. And we can also talk of maybe just for exclusive use of the piece of land. So you can say this is where a non-owner of a piece of land gains ownership to the land, a non-owner of a piece of land gains ownership or title to the piece of land after a certain period of time. And the reason normally is continuous usage of that land, as a result of continuous usage of that land. This is very common with the squatters and something called the squatters' rights. When they stay in a piece of land for a considerably long period of time, then they might claim the ownership to that piece of land. That is what we call adverse possession. You are a non-owner, but through the legal processes, the land can, the title or ownership of the piece of land can revert to you as a result of continuous usage and over considerably long period of time. Then B, outline 4 disadvantages of solving disputes through alternative dispute resolution. Outline 4 disadvantages of solving disputes through alternative dispute resolution. Number 1, the advantages of solving disputes through alternative dispute resolution. Now, when we talk about alternative dispute resolution, we have we can be talking about arbitration just before we start listening. Arbitration, we talk about mediation, we talk about conciliation, and the group. These are alternative dispute resolution methods. So, what are the disadvantages of these ADRs that we have just mentioned? Number 1, if they are unsuccessful, it simply means that we have wasted a lot of time. If they are unsuccessful, it simply translates to a wastage of a lot of time, and it can even delay the court proceedings. It simply translates to that, a delay of the court proceeding, because you will have tried it and then it will fail and then go back again to the court. So it's a wastage of time and also a delay to the court proceedings. And unfortunately, some people sometimes use this just to delay the court proceedings. Then except for arbitration, the ADR, whatever it is that they are going to agree on, is not legally binding. Except for arbitration. Arbitration, whatever it is that they are going to agree to come up with, will be binding upon the parties, because they agree in advance that whatever the decision of the arbitrator will be final. But if for these others, the decision may not be legally binding, and of course that one comes in as one of the disadvantages. So the decision is not legal binding. The other one is that the parties must agree. And again, with the exception of the arbitration, because in arbitration there is an arbitrator and his decision is final. But for these others, mediation and the group, parties must agree. And of course, that one comes in as an advantage, but also as a disadvantage. As a disadvantage because of really a wastage of time, and it may not be easy for these parties to agree. Sometimes they will not agree, and you see, we'll still have wasted a lot of time. Then again, the other the disadvantage is that the arbitrations don't guarantee solutions to the dispute. They don't guarantee solution to the dispute. They just try if they can possibly reach an amicable way of solving the dispute, but they don't guarantee solution to the dispute. Of course, it also has costs, and the parties bear the costs. That also comes in as a disadvantage, especially the venue where they are going to meet. If it's arbitration, the cost of arbitration, the arbitrator. So all those are some of the costs that will come with this process. And of course, it's a disadvantage, whichever way you look at it. Limited powers of compulsion. Limited powers of compulsion. In case one of the parties fails to comply. In case of failure to comply, what you are saying is that the alternative dispute resolution may not have enough force to force any of the parties who has failed to play his part. Unlike the court can give orders, but the alternative dispute resolution may not have the muscles or the teeth to force a party that has failed to comply to comply. So that comes in as one of the disadvantages, that it has limited powers that may not necessarily force or ensure enforcement of the decision that they have passed. Then limited appeal rights, especially for arbitration, limited appeal rights. Remember what we said, that arbitration decisions are final, but these other decisions are not final. So for arbitration, you have limited appeal rights because you are accepted to be bound by the decision of the arbitrator. And like these others, you, of course, you have to agree. And if you don't agree, you can always appeal. It's arbitration that has that particular disadvantage, and because it's one of the ADRs, you can have it. Then information may be given away in the process. Unlike courts, in courts they say anything that is in the court, you're not supposed to discuss it. But in alternative dispute resolutions, people might give out information in the process, and of course it might also hamper or affect negatively the whole process of justice seeking, and all those come in as disadvantages. So I think what you have noted here is that arbitration has its disadvantages, mediation has its disadvantages, conciliation has its disadvantages, and the question is general, that outline 4 disadvantages of solving disputes through alternative dispute resolution. But there are so many alternative dispute resolutions, so you can just go explaining, and of course with the exception of this, like that, so long as it's a disadvantage of alternative dispute resolution. So it was quite an open question, and like if it was just targeting one particular alternative dispute resolution mechanism. Thank you. Let's meet the next. Let's go to the next bit here. This is part C of the question. With reference to a corporation as an artificial person, enumerate 3 legal rights. 3 legal rights of a corporation as an artificial person. This is a company, and a company is an artificial person. So what are the 3 rights of a company as an artificial person? 3 rights of a company. Number 1, right to own property in its own name. Right to own property in its own name, in its name. The companies can do that. Right to sue and be sued. To sue and be sued. The companies again can do that. And the company also has the right to enter into binding contracts. All these are rights that are reserved to the company, simply because it is it's an artificial person. So it has the right to own property in its own name, right to enter into business agreements and contracts, binding contracts, and we can also say it has right to be protected, right to be protected, right to protection by the law of the day, because it's a person just like any other person. It's just that it's an artificial person and we are natural people. But because it's an artificial person, it's a person, it has the right to be protected by law, just like a natural person. So pick any 3 here. Then 3 legal responsibilities. The first legal responsibility of a company as an artificial person is to have a registered office. All companies must have a registered office, location for the registered office. That's a responsibility. They must make sure that they have a registered office. Then the companies must also they have a responsibility to, actually it's an assumption, going concern, continuous, perpetual existence. It becomes a responsibility that they are supposed to. It's one of the key characteristics of a company, that a company is a going concern. So the responsibility here is to make sure that it is operational and for a considerably long period of time, because it's going to enter into very serious contracts in its own name. that is now one of the key reasons why this becomes a responsibility to keep going, keep going, keep going. It is a responsibility that is expected of companies. And then it also has the responsibility of making sure that it has a common seal. It is this common seal that allows it to enter into contracts, binding contracts in its own name. So that also becomes one of its responsibility. And of course, the other, I don't know if it's a right or a responsibility, transferability of shares. Yeah, transfer shares can come under the right to transfer shares. Yeah, but anyway, this, we have the 3 legal rights here, and we also have the 3 legal responsibilities of a company. Let's go to part D of this question, which also happens to be the last part of the question. Explain 3 types of exemption clauses that could be used in a contract. Examine 3 types of exemption clauses that could be used in a contract. Now, maybe you start by defining these exemption clauses. What is an exemption clause? An exemption clause is the what if of a contract. What if of a contract. You can simply define it like that. Examine 3 types of exemption clauses that could be used in a contract. And what we are saying is that an exemption clause is simply the what if of a contract. What if this happens? How liable are you? Will you be liable? To what extent will you be liable? What if this happens? So that is the exemption clause comes in the moment you start asking about the what ifs. What if it happens? How? What is the percentage of your liability? Are you liable? To what extent? Those are the questions that we'll be asking. So examine 3 types of exemption clause that could be used in a contract. Number 1, we have exclusion clause. Exclusion clause, and this is where a party is eliminated. That is where a party is eliminated from any responsibility. A party is eliminated from any responsibility in the case of a breached contract. It's very common where companies say that we are not responsible for 1, 2, 3 things should they happen. So exclusion clause, where a company clearly says that it will not be liable for certain set of actions or activities or something like that. So that is elimination from any responsibility in the case of a breach of contract. Elimination from responsibilities in the case of breached contracts or any other thing that we could be talking about. Then we have limitation clause. Limitation clause. And limitation clause, this is where a party is not totally excluded. A party is not totally excluded, from the liability in the case of a certain event. So the liability generally has limitations. A party is not totally excluded. For the first one, a party is eliminated, totally excluded. But for limitation clause, a party is not totally excluded. So the contract generally, or the liability, has some limitations. It will only apply if, like that. So a party is not totally excluded from the liabilities. And here a party is eliminated from any responsibility in breach of contract. Limitation clause, a party is not totally excluded from the liability in the happening or in the case of a certain event happening. Then we have the last one, indemnity clause. Indemnity clause is where one of the parties is totally excluded. One of the parties is totally excluded from the losses because the other one has voluntarily accepted to take care of his losses. It's an indemnity clause is happens basically in the insurance contracts. Where one party undertakes to indemnify or compensate the other party should a loss occur. So the other party who is supposed to suffer the losses has been protected from the losses. There will be another party who is better positioned to cushion him against the loss that will come up and take over the losses. So what are we saying under the indemnity clause? That one party agrees to compensate the other in case of harm or loss. One party agrees to compensate the other in case of harm or loss. So this simply means that the other party who will be compensated has been excluded from or exempted from suffering the loss. And so that marks the third type of exemption clause. We have exclusion clause, we have limitation clause, and we have indemnity clause. Thank you. Let's meet in the next question.